Started this morning. Welcome to our community development meeting. It's June 15th, 2023. The time is 9 a.m. I'm calling this meeting to order. In attendance are Commissioners Brooks, Matari, and Duncan. Commissioner Brooks has joined us by telephone. Are there any changes to the agenda? The only things I might add, an executive session if we need it for item 4. And my opening remarks are, these are deliberations, so there won't be any public testimony at this point. It's just the staff conversing with the board, and the board will make a decision, or the board has an opportunity to continue deliberations to a time in the future. All right, conflicts of interest on any of our 4 cases. Are there any?
No.
All right, thank you. We'll go ahead and start with item 1, which is MSF 23-0001 Humbird Acres. And Vlad, are you leading us?
Correct. Good morning, Commissioners. For the record, Vlad Finkel with Kootenai County Community Development. As you stated, this is a request for a final plat approval of Humbird Acres, a major subdivision request by Round Mountain LLC. The subject property is located at the intersection of Scarcello Road and Ranchview Drive. The applicants received a preliminary approval of a 16-lot major subdivision on 80 acres in the rural zone in December of 2021. Since then, the applicants have requested a site disturbance permit for the construction of the interior road to serve the proposed lots. The property is fairly flat. It's a pretty standard subdivision request, with the interior road bisecting the property and providing access to the internal lots. Each lot will be served via individual wells and individual septic systems. Originally, the applicant requested to extend Ranchview Drive as a public road, meaning that it would be constructed to the Associated Highway District standards and dedicated to the Highway District. This is how the board approved it in December of 21. Since then, the applicant has decided to retain the road as a private road in its own road track without dedicating it to the Highway District, and however, it would still be constructed to the Associated Highway District standards. Pursuant to our code, they requested that we make a determination whether the significance of the road dedication from public to private and being maintained by the Highway District would be considered to be a significant change and require that they go through a second round of preliminary review. Based on discussion with our legal counsel as well as the Highway District, it appears that this is really a non-issue so long as the road is properly constructed and maintained by an entity. That has since been done. The road has been constructed. There are some minor remaining improvements like signage and striping that the applicant did submit a bond for. But other than that, pretty much all of the improvements are in place. We did verify that the original conditions of approval set forth in the December 16th, 2021 decision have been complied with. You did receive the director's recommendation addressing each condition separately, and we believe that at this point there are no issues with the applicant moving forward and recording the Mylars and recording the CCNRs that would stipulate the future maintenance of the interior road. I stand for any questions that you have for me at this time.
Is that going to be a property owner's agreement for the road?
Actually, it's going to be covenants, conditions, and restrictions that have been drafted. They have specific provisions for the maintenance of the interior road. And it has been constructed to the Associated Highway District standards. We did receive a response from the Highway District engineer. They did enter into a road development agreement for any outstanding improvements that may be necessary, and that has been signed and accepted by the Highway District as well.
Okay, and was this a Highway District request or was it an applicant request?
It was an applicant request, and this was done early on. As soon as we received the preliminary approval, I'm not sure why the decision was made right after the preliminary approval. But we have seen this before. In fact, we processed another major subdivision recently that had a similar situation, and neither the board or the highway district had any concerns, so long as the road is constructed appropriately and maintained in perpetuity.
Okay. Questions for Vlad?
No questions.
Okay. Bill, questions?
No questions.
Okay. I don't see an issue with this approval at this time.
You want a motion?
Yes, please.
I move that we approve Humberg Acres MSF 23-0001.
I second the motion.
Bill Brooks,
Aye.
Commissioner Matari,
Aye.
Chair Duncan.
Aye. All right. Motion passes, and MSF 23-001 has been approved. We're on to item 2, which is a variance, VAR 22-0007, Zimmerman. And Vlad, is this you as well?
Correct.
Okay.
Commissioners, this is a request in what will be a very familiar location of Kootenai County for you. We have received numerous requests over the years. In fact, I probably processed in the last decade over a dozen of these variance requests to front yard setbacks on Lower and Upper Hayden Lake Road. This is no different than any of the most recent ones that we approved. The applicant is seeking to have a variance of 15 feet to construct a residence within 10 feet of the prescriptive right-of-way for Hayden Lake Road. The subject property is very steep, as you know. It does have an existing retaining wall in this location. As you can see, the applicant will likely be removing a portion of that retaining wall that spans along their property and adjoining property to the west, and in order to construct their residence, but that the design and engineering of that has not been finalized at this time. The property is zoned restricted residential. As you can see, the front yard setbacks are 25 feet. Originally, the applicant requested that in fact, their original request consisted of a 0-foot setback or 25-foot variance from the prescriptive road right-of-way, as well as a 5-foot setback on each side of the property, east and west side. We advised the applicant we would not support those variances because having the structure right on the right-of-way is, in our view, poses a safety issue for the traffic on the road, as well as sight distance entering and exiting the site. And we didn't support the application for side yard variances because we didn't see there being an issue in that regard. We felt like the applicant wanted to, to maximize their footprint of their residence, and we felt that that was a self-imposed action on their behalf, which the code prohibits. The applicant took our concerns under advisement, and they changed their position. They then removed the side yard setbacks and are now seeking they were still seeking a 0-foot setback from the road right-of-way, but the highway district in the original response rejected their request, as you read in the staff report and HE recommendation, and then they decided to move the residence 10 feet from the right-of-way, making it a 15-foot variance as being proposed. These are some of the photos. This is the retaining wall. Actually, the residence will likely sit in the location where the retaining wall is currently located. This is the proposed site plan. As you can see, it has really steep slopes. The purpose of this variance is to move the structure as close as possible to the road so that it does not warrant the disturbance of the hillside and stormwater features, as well as retaining walls. And that's been a common argument by a number of property owners in that area, and we feel like it is a legitimate concern that staff can support. They did submit a geotechnical analysis, as some of you may know. There is a history of unstable soil conditions along that hillside. In fact, there were slides in the past. So we make it unambiguously clear we will not support any variances until we receive a geotechnical analysis that provides field work and analysis and conclusions that it is possible to build the structure in that location. Of course, if this is approved, further review of the geotechnical evaluation as well as site disturbance and stormwater conveyance will be done at the time of building permit application. We did receive comments from all the agencies. Like I said, the only one that requested or rejected the original variance of 0 feet from the road right-of-way was the highway district, but since the applicant changed the variance request to have a 15-foot variance, now it's acceptable to them. We received a couple of, or one comment in opposition, 2 in support. I think the concern was raised with regard to the structure in relation to the public right-of-way and site distance concerns. We feel like if the highway district does not have those concerns, they're the experts. We feel that if they support this application, it's a non-issue. We feel that there is an undue hardship for the approval of front yard variance. We believe it's not self-imposed. And other than that, I don't have anything else to add except for that the hearing examiner heard this request on May 18th of this year and subsequently submitted a recommendation of approval.
All right, questions for Vlad?
No questions.
I have a couple. Are we still considering an overlay district for this area?
It's on.
Commissioners, David Callahan, Community Development Director. I have let that lapse, not purposely. We've just been overwhelmed.
Sure.
I think to answer your question, we could do that. I would need to hire a consultant to
Yeah.
help us do the work.
All right, well, I mean, at this point, it should be built out soon, right? Area. So,
Well, it's somewhat embarrassing to say, but yes.
okay.
Yeah.
There are other parts of the county where.
Oh, yeah,
overlay
Silver
would-
Beach and, yeah, there's several of them, but, okay, that's fine. I figured as much. And then Vlad, is the size of this residence kind of in line with the neighborhood? It's not any bigger or smaller than most of the houses there?
Chair Duncan, I think going back to my introduction, we felt that the original proposal having 5-foot side yard set on each side and requesting a variance of 5 feet because the setback requirements in the restricted residential zone are 10 feet would have made the structure significantly larger than the existing residences in the area, simply because I haven't done the research on the square footage of those buildings, whether the footprint is larger or the square footage being several stories tall would be significantly different. But what I do know is that we have not approved any side yard variances recently that I can recall. And in my view, the encroachment into the side yard setback would make the structure significantly larger. By having it set back to 10 feet and having the applicant withdraw their side yard variance, I think it's in line with the other residences in the area.
Okay,
And that's my recollection too. That, just from the eye test, it looks consistent with other structures that have received approved variances.
all right, thank you. Any thoughts?
No?
I think we should approve it.
Okay, motion?
I move that we approve VAR 22-0007 for Zimmerman.
I second the motion.
Bill Brooks,
Aye.
Commissioner Matari,
Aye.
Chair Duncan.
Aye, all right, motion passes. So VAR 22-0007 has been approved. And now we're on to item 3, and this is MSP 22-0007, Bennett Estates. So this is a major subdivision. This is preliminary approval. And Vlad again? Amy, are you just hanging out today?
I'm here for the appeal.
Oh,
Yep.
okay. All right.
Commissioners, Chair Duncan just stated that this is a request for preliminary approval, so this is to, the board's decision in this case is not to confirm whether the conditions have been complied with, like in the other application that I presented this morning, but this one is to assess the applicant's request, staff's recommendation, as well as the hearing examiner's recommendation. This property, as you may recall, had recently gone through a zone change from agriculture to rural. In that case, number was ZON 22-0004. The application went before the board in early May of this year, and the board at the time stated that they were not opposed to the zone change. But they would have, they will review the subdivision on its own merits and make a decision, in this case, separately from the zone change. So the zone change is not a precedent setting for the approval of the subdivision, if that's the right way to put it. The subject property consists of 80 acres. It's located at the intersection of Highway 53 and, just a second. I think it's Mountain View.
Mountain View, yeah.
Yep, Mountain View Road. The subject property is fairly level. This is a bit of an outdated Google Earth overlay map. There has been a logging road that was recently constructed in this area. I don't think it plays a significant difference in what the application is about. They will have an interior road constructed in that location to serve the interior lots if it's approved. As you can see, the area development is very similar to what the applicant is requesting. There are multiple parcels on all sides of this property that range from 5 acres to 10 to 20 acres in size. So this request, from a compatibility and consistency standpoint and density wise, is very similar. 5 acre parcels, total of 16 parcels provided by Interior Road. I forgot to mention that the comp plan is suburban, and suburban designation does allow for a development of underutilized larger parcels of land in Kootenai County. This is the layout of the subdivision, similar to the previous major subdivision request you heard this morning. There will be a total of 16 lots. There will be individual wells and individual septic systems, and access will be off of Highway 53. These are some of the photos of the property in question. Like I stated, a portion of it was recently logged for logging Interior Road. But other than that, it's fairly level and should not pose any issue in terms of development and site disturbance containment, or just containment of stormwater runoff. We did solicit comments from agencies with jurisdiction. They're pretty standard. ITD will require that the applicant submit and get an approval of an encroachment permit from State Highway. The Interior Road will have to be constructed to the Associate Highway District standards. Panhandle Health District will review and approve septics. Fire and building really had basic comments as well. We only received 3 comments in opposition, and all of them were stemming or in relation to additional traffic. I don't necessarily disagree that there will be additional traffic, but because neither ITD or the Highway District raised any concerns, we don't find that to be we don't find that to be a significant enough issue for us to recommend denial of their request. Staff analysis is that the property was recently rezoned, and in that decision, the board did find that the rezone and the potential development would be compatible with surrounding development. The proposed density and lot sizes are consistent with the existing development pattern in the area. The applicant must comply with the agency requirements and prior to submittal of a final plat application, and they must construct or bond for those improvements prior to final plat approval. The hearing examiner heard this request on June 1st of this year and subsequently submitted a recommendation of approval. I stand for any questions that you have for me at this time.
Bill, questions?
I have no questions.
Bruce?
I don't have any questions. Thanks.
Are you sufficient then to go ahead with this, or did you want more time to review?
I'd like a little more time.
Okay,
We're just talking 2 weeks here.
sure. So is it a problem? I think it's actually less than that. Don't we have a meeting on the 22nd?
Next Thursday.
Yeah. So you
1
want a week?
Yeah, that's fine.
Okay. So this information was not in our packet, and I know that we just approved the zone change, so I think we'd like a little bit more time to review this and dig into it. So I will point out that the Sheriff's Department said they had no objections to it.
Yeah.
So, all right. So then I would take a motion to continue deliberations to June 22nd.
I move that we continue deliberations until June 22nd for MSP 22-0007 Bennett Estates.
I second the motion.
Bill Brooks,
Aye.
Commissioner Matari,
Aye.
Chair Duncan.
Aye. All right. And our final deliberation for this morning, this is appeal APP 22-0003, and it's the appeal of the minor subdivision of 21-0043. And I was able to watch the proceedings from the public hearing on this, so I feel like I'm prepared that I could make a decision if the board is leaning towards a decision today. I guess one of my questions is kind of a legal matter, so where are you at, Bruce?
I'm ready to make a decision.
Okay.
So,
I guess, can I listen to his deliberations and then decide if we need to go into executive session?
Yeah, you can. You can make that motion. That motion can be made at any time. I would just, and it would require a roll call vote, which we always do anyways.
Sure. All right, go ahead.
I'm going to go ahead and make my statement here.
Sure. Oh, because we don't have any, Amy doesn't need to do a presentation or
Right,
anything.
yeah, you don't need anything else from us.
Great. Okay, go ahead.
Yeah, I'm just going to go right to the conclusion here of what I put together, but it's clear the original property owner intended to develop a series of parcels to be bound by a single set of CCRs. If that were not the case, then the same set of CCNRs would not have been recorded on the various parcels. Further, the parcels would not be associated with the same development. What's at issue is the parcels were not technically bound together with a single set of CCNRs and therefore are only bound to the CCNRs on their respective properties and to no others. Whether this process was executed with perfection or not is immaterial. It is the intent of the community that matters. We use intent in all other aspects of law, which is why we keep records of the intent of legislative bodies when bills are drafted and passed. This isn't a failure to attach the same CCNRs to every parcel the original owner intended to develop. This is a procedural issue, as I see it, of how the parcels were entered into the subdivision, which one could reasonably argue the original owner could not be expected to know at the time and would be heavily reliant upon outside counsel to help navigate. To allow for a technicality to invalidate the subdivision and its CCNRs to bind the various parcels together would have a significant and detrimental effect, in my opinion, on the community as a whole, especially given the fact that the intent and understanding of all parties was that all of the parcels were bound by the single set of CCNRs. Further, by allowing such a technicality to invalidate this set of CCNRs, precedent could be set to invalidate communities throughout the state that failed to follow, quote, perfect subdivision process, end quote, and allow the members of each of these communities to suffer because of a procedural misstep. While I recognize that this issue most likely will need to be settled in a court of law, I have concluded that the CCNRs were intended to bind all of the parcels together, and that the subject property cannot subdivide further than its current acreage, and thereby vote in favor of the appellant.
Okay, which is upholding the hearing examiner and ruling against the county.
Right, reversing this, the decision of the
Yeah.
director is what
Okay.
that would do.
All right, Bill, thoughts?
Well, those were good arguments, comments by Bruce. I agree completely.
Okay. I still have a
Madam
legal
Chair, just a
question.
second, would you
Yeah.
like to enter your written statement into the record?
Entered into the record as, what would
The
it
public
be?
hearing's closed. I mean, is that okay to?
Yeah,
it's
I mean,
just-
it still needs to be in the record for,
Okay.
especially if it does go to judicial review, so.
B 1000.
Let me think here. I guess, Pat, I'll ask you, should we go into executive session or,
To be honest, I'm only comfortable doing that if it's a procedural question. I don't feel comfortable answering a substantive question at this point because
It's
it would basically
procedural.
be an ex parte contact
yeah,
at this point because I did give the argument on behalf of the county.
yeah, it's procedural.
Okay. I mean, it depends on if you're comfortable asking it here on the open record or if you would like to go into executive session to discuss it.
That's a good question. All right. If the board goes ahead and denies this, which is keeping with the hearing examiner's thing, is that what obligation does the county have when this goes to court?
I would defend the Board of County Commissioners' decision, whatever it is.
Okay. So you would change kind of from defending staff's decision to the board's decision? Okay.
And, you know, we can always assign another attorney to it if anybody feels that there's a conflict for me doing it. I'm comfortable doing it. But if you're not, we can get another attorney to do it.
Okay. All right. I guess I'll take a motion.
I'll take a stab at this. I move that we rule in favor of the appellant for APP 22-0003 for the appeal of MIN 21-0043.
I second the motion.
Bill Brooks,
Aye.
Commissioner Matari,
Aye.
Chair Duncan.
Aye. All right, the appellant has been upheld, and that's it for deliberations. So we can go on to our business item, which is the community development fee resolution. And I have already spoken to David Callahan about my concerns. Sorry, I'm just getting to the packet. On some of the fees that were raised, and I want to make sure that we are talking about the director still being able to make decisions on waivers. All right, and now I've got it up. So, David, do you want to lead us in this?
Sure,
or
I'll be
just
glad
talk about
to.
it?
David Callahan, Community Development Director. First, just to set the stage, today's a discussion item. Your actual hearing is next Thursday at 10, and it has been properly noticed. There is a housekeeping matter related to that notice, though. What was actually published in the paper missed a line item. There should have been 2 lines, one for permit reactivation and one for reinspection. And that actually is the case in the resolution. So the resolution's fine. It's just what was in the paper was an error. And so I'm thinking, unless Pat thinks differently, we probably need to republish that portion of it, or re-advertise just that portion of it. And then we could circle back around again with that portion later.
Yeah, this resolution would omit those 2 fees, and then we would just go through the process again for those 2 fees.
Okay.
So can you tell me where on my
On the
paper
second
2 fees?
page of the resolution or the second page of the notice, it's under building division fees. Drop down underneath where it says additional plan review, keep going.
Oh, okay.
Permit reactivation.
Yep, I see it. Okay, I was looking at the planning fees, not the
Thank you.
building fees.
Which
Okay.
one's permit reactivation?
Yeah, that should be.
See, on my legal notice, they're there.
So these are not changing. These amounts are not changing, so why would we
Actually,
need to?
they are, as I understand it. We don't
Oh, yeah.
actually have a,
One by $20 and one by $50.
first of all,
Yeah, if the notice was published the way, from what I have here.
Oh,
then it would be
well,
fine.
Christina was the one that brought this to my attention. She thought there was a cross in the mail email between you and what we ended up with.
Okay, there is one I see that is missing, that's building reinspection.
Yeah, so these 2.
But, oh, I see.
So is that,
Yeah, they didn't get broken
yeah,
out.
see where that says
Yeah,
or?
yeah, but the temporary CO is fine.
Okay, so that, instead of it being or reinspection, it just needs to be building
Yeah,
reinspection and permit reactivation.
Yeah, we'll have to go back and
Renotice that.
yeah.
Okay.
So I don't even have that. On mine, it says 100, 100. So I don't know why my paper's not correct.
Let me see what you have.
Yours
What's
out
in
of the
the
folder?
electronic
Or
file?
I got this a long time ago.
Oh, okay.
Okay.
If
All
you
right.
open
Yeah, then it's been
today's
changed.
electronic file, it's got this in it.
Yeah,
which-
I'm looking at that right now, and
Okay.
it shows it on there. But you're saying that wasn't published? Because that's part
Right.
of the resolution?
It was,
That is what I'm saying.
yeah, what happened was the notice says building permit reactivation or reinspection
On one line.
going up from $100 to $120. So we can approve that.
Okay.
But to raise the reinspection fee to $150 would require another process.
Okay. So how much are we going to spend on publication versus how much we're going to make by increasing the fee $50?
Or $30.
Or, yes, $30.
It's $30, $40 for a notice in the paper. So I will recoup it.
In one
Yeah.
shot. Okay. All right, and this reinspection, so is this every single time they go out?
Yes. But there is something of a judgment call by the chief building official
Okay,
of when we throw that number in there.
okay.
But just to answer your question with more specificity, it's not uncommon for us to correct the same thing several times.
Right, which in that case, I would argue in favor of a reinspection fee. So, okay, so I'm fine with that one item being republished and we approve it later, unless somebody has a different thought.
I'm good with it.
I agree.
Thank you. And then I think you're, as a big picture view, you're well aware that this is really a group effort with the auditor's staff and my staff. All the division managers on my side have weighed in. The auditors have been very helpful. We think this comes pretty close to the actual cost capture of what you can expect an applicant to pay. where the chair, Duncan, had some concerns was under conditional zoning development agreements, cottage industries, appeal of administration determinations, and request for reconsiderations, with the concern that the numbers are starting to get pretty high. And it might prevent people from actually appealing or asking for a reconsideration. And that, is truly a judgment call on the board's part as to what you want to do.
Well, I have some questions. Is there an opportunity to take a portion of that fee? So I guess, let's just say cottage industry permit. It's $1,178. Could we take some portion of that and prorate it with other fees? So it's kind of built in.
Oh, like a percentage of a.
Yeah, so like,
I think I hear you saying we bump up other fees to capture this.
to capture some portion of it so that it's not fully loaded onto that one person.
Maybe if we
But-
bumped up every fee we do, I'm just trying to think of a way to make it.
But you understand what I'm asking now, yeah.
I do. Is it, so
Understand?
taking it in, is it a cost of doing business that we can proportionate?
Yeah, so if a fee is $100, and let's say we call that a very expensive fee, let's take 50 $1 units and apply them to the other fees that people normally pay. And so that way, it's kind of like an insurance policy.
Subsidizing.
Well, it's an insurance policy in essence, so that if you feel like you need to appeal something, you don't have to pay the full fee. It's already kind of built into your initial fee. So it lowers that appeal amount.
Okay, so are we talking about the cottage industry or are we talking about the appeal?
Well, I was just using that as an example, but the appeal could be, it's just a matter of finding a way to prorate some of these fees and apply them across the board in that process. So
The philosophical question you raised, one I hadn't really pondered, which is it fair to get all the rest of the applicants that do business with us to pay a proportionate share towards things that they may not actually use?
well, they're buying it down, in essence.
They are,
They're
but is
buying
that
it down.
fair?
Well,
I don't know.
So
That's your call, not mine.
Yeah.
I rather put it across all the taxpayers of the county because we don't know who is going to
Right.
need this service or not. I'm also comfortable giving David direction on being able to administratively adjust some of the fees depending on the circumstances. That can get kind of hairy because I don't want to,
you get into
I like you
arbitrary.
and don't like you.
Yeah.
Kind of thing. So I was kind of thinking for the cottage industry stuff, if we said, okay, it's a max of 1178, and then we went based on number of employees in the business or something to that effect, that we could prorate it down from there.
And I just did add in language the resolution that would allow David to adjust or waive fees within his sound discretion.
Okay.
And there is a resolution from 2020 on file that continues, that gives me authority to waive fees as long as it's not a direct cost.
Yeah.
Well,
So I understand what you're saying, but I rather give it to the taxpayers I'd rather have taxpayers subsidize it than actual other people who are trying to do stuff on their property.
yeah, I guess I see it a little differently because the taxpayers are the ones that aren't involved in any of this, and the people who want to improve their property, it's just part of the cost of improving your property. And I as a property owner, wouldn't want to be subsidizing other people's improvement efforts. I mean, I see your point because it spreads it out, and then but I just see it a little differently. Bill, do you want to weigh in a little bit?
Yeah, I think the people who are causing the need for the reinspection should be charged, not shouldn't be spread out over taxpayers.
As an example.
Yes.
Okay.
Can you name the particular fees that stood out to you?
Yes. So,
Cottage industry.
yeah, cottage industry.
Permit.
So actually, I have a couple ahead of that. Conditional use permit, non-commercial, that went up $441 to $3,000. So like almost $2,600 increase. Conditional use permit renewal went up about $1,400. And then a CZDA, conditional zoning development agreement, went up $300. My only issue on the CZDA is if the Board of Commissioners is asking for that, then I don't think that they should pay the full amount because they're not requesting it. The commissioners are. Now, sometimes they do. Sometimes they come forward and say, you know,
That sounds like one where I'd be able to waive it. Do you agree?
Yeah, I would think so, since it's a county initiated.
right, or even 50% or, you know,
Or
something.
soft costs.
Soft costs, yeah.
Keep it where it was.
Yeah, we can keep it where it was as well, so,
Oh, that's an option.
yeah. But he still has the right to waive it. So,
All right, so we addressed the CDZA,
okay,
the conditional use permit, non-commercial.
yeah. So we just approved a doggy daycare and the impact was very, very low. So to charge that business for ends up being non-commercial only because of their low impact and their amount. I forget all the things from the case.
But it's still a business though, right?
It is, but it doesn't rise to that level. It's more of a, not even a cottage industry.
In this case, the cost of the fee would be more than the person would make in a year.
Yeah. Yeah. So that was just one example. There could be other examples.
What comes before the conditional use permit? Is there any other application process? Is there?
No, it's just staff meets with them, and then they
So
collect
storage
the fee
units.
when they apply at the front counter.
Yeah, so storage units would be commercial, and so I think that's appropriate. But for a non-commercial conditional use permit, would that also be having the railroad cars as a storage facility on your land? Would
That's
that be
a
a
special
non-commercial?
notice
permit.
That's a special notice, okay.
Different creature.
So I can't even really give a good example of a non-conditional CUP, I mean, non-commercial.
How did we arrive at these numbers? Just curious.
Using
Staff
the
time.
staff time and salaries. And,
Wow.
Yeah.
I know,
I mean, that's expensive.
yeah. So we can keep it, and I think it's so rare that we could probably just keep it the way it is anyway.
What are the fees right now?
$441. Yeah,
That's-
$441 to $3,000.
Can we cut the proposed fee in half?
You can do anything you think
I mean,
is
that,
appropriate.
you know, I'm throwing this out there for discussion, you know?
It's still a lot, but as long as the director has that, you know,
I mean, I don't mind making a ceiling half, but if it is going to take a lot of staff time, I mean, you know, you should kind of pay for that a little bit.
I understand, but in this doggy daycare situation, they may just operate outside of permitting if it's going to be cost prohibitive to do that. So that's what I don't want to do. I don't want to force people to disobey the law because they can't afford to obey the law.
Yeah.
Well, I don't want to use one example as the driver for this, you know?
I understand,
think
but
that's
I've
too
asked
much.
for other examples.
But if
and I don't have any.
if the community development director has this discretion, then that addresses the one. But if it's going to take, you know, resources and legitimate
Sure.
costs, I mean, at this point, if it really does cost $3,000, then we are allowing the county to subsidize half of that, which seems
Sure.
reasonable.
Okay, so you want to just take that to $1,500?
I'm okay with that,
Okay, yeah, $1,500 ceiling.
and the same with the renewal.
Okay. So half of the proposed increase? or half of the whole fee, because that's.
Half of the whole fee.
Then I would keep the fee at $22.53 then. Just keep it what it is now.
Oh, well, I'm sorry. I was under the impression that the
Yeah,
ratio
I
of the
have
non-commercial.
no, I have the.
That's fine, 22.53.
Okay.
Okay.
We don't have a lot of these, but
Right. But then again, I don't want to discourage people from doing that. Okay, so then I go to the variance and, which 3,200 up from 2,000's kind of a lot, but there's probably a lot that goes into that. So I would more be concerned about the administrative variance that went up again from $441 to $2,000.
I think it's fair to say one of two things has to be true. Either we missed the mark today or we've been subsidizing significantly in the past.
Sure. And I would say I'm sure we've been subsidizing. But once again, how many of those are done?
Not that many. Administrative variances are a handful a year.
Right. And the other issue too is, are we using your salary? Because, yeah, that would be one of the
That's part
reasons
of it.
why.
I mean, I'm
Yeah.
part of the team.
Yeah. No, I know. You just are hopefully paid more than your team.
I am.
Yeah.
what was it before?
$441 up to $2,000.
I mean, the community director has some discretion on this, right?
Yeah.
Right.
I mean, do these all take the same amount of time?
They're highly variable.
I mean, I'm okay with you using your discretion and then just, making that a ceiling
Okay.
so that there's like kind of a time and material up to.
Makes sense.
Okay. Thank you. All right, and then I think the last heartburn I have is appeal of administrative determination. And unfortunately, I mean, it's gone up $1,000, but the issue I have is I don't want to hamper due process because people can't afford to appeal. So,
That's the perfect situation to prorate a portion of that across all the applications.
okay.
So that way you're buying down that appeal process. Everyone pays a little bit into it, but if they want to use it, it's less expensive than what it actually costs.
Yeah, so the appeal, I would agree, and to do that as well with the $750 reconsideration, because everybody who comes and makes application will have the opportunity to appeal if they have a determination that is not.
So we build it into the initial
Yes.
application.
Yeah, so I would be okay building that in across the board, but I don't think we can do that now that we've published all of our fees.
Yeah, you couldn't do it. You couldn't do it this time. It would take it, again, would take a separate process.
Right. So I would be willing to leave the fee off the reconsideration and keep the administrative determination appeal the same amount as last time. Then next year, because we're going to be looking at these fees every single year, that we go ahead and make those changes next year. And it may be less than 5%, so we may not have to publish.
Do these are these appeals have a variance in effort and time? Or are the straight, pretty much a consistent cost across the board?
Oh,
Because if there's a variance, I'm okay with just letting, again, the community development director use discretion based upon a time and material up to. I mean, I think we have to have a ceiling, right, when we advertise these things? You can't go past the ceiling,
right.
Correct.
but you can go up to if you can show, well, this is how much we put into it, so this is what your
Right.
fee would be.
Right.
And I think it's important that we use the expertise of David Callahan in this regard. How many years do you have in community development, David?
43.
That's it?
Al? So I think he should have a lot of discretion, but we do need to have a ceiling, of course.
Is that okay?
Yeah, that's fine. I'm
Just
just
for my clarity, is
sensitive.
that for the appeal of the administrative determination
Both
and
reconsideration
the reconsideration?
What
Yeah.
would the reconsideration be then?
Um,
Would we just, would it be no fee or would we charge a fee less than $750?
right now it's no fee and it
Right.
would be
Right.
$750. That
Right.
just seems so much. I mean, I just can imagine my neighbors if they needed to file for reconsideration. That's just
500?
still a lot. Not for you.
It's not how much, I mean, we're talking about, the way things have happened in the last few years, there's been a lot more millionaires minted in this county.
I don't doubt it. I just
No.
don't live near them.
Well, I certainly understand there's great disparities each way.
Yeah.
I get that more than most. I've watched it for the last 40 years. It's gotten worse and worse. But I think the hard balance you've got to call is how far do we subsidize and what's
Right.
reasonable for the people affected?
So for appeals, see, this is another area of heartburn for me. I don't like people who appeal for the sake of appealing. Oh, I didn't get my way, I'm going to appeal. But if they have a reasonable thing like this last one that we just,
Right.
then I think that's,
Well, what about this? Again, I'm just spitballing here a little bit, but what if that is the fee for the appeal, but if they prevail in the appeal, they get half of it back or something? That way, you got to put something into it,
Yeah.
but if you end up being right, then you're not penalized fully for it. Is that a possibility?
Yeah.
Makes sense.
That makes
Yep.
a lot of sense.
All right.
okay, good. So half.
if the appeal prevails, you get half back.
Yes.
Okay.
That'll weed out the.
Right. And can we just have that memorialized in internal documents? We don't have to publish any of that, do we, Pat?
No, not necessarily.
Okay.
So are we going to charge a fee for reconsideration or are we going to
I would say yes.
Yes.
How much?
I guess leave it at 750, or I don't know, do you want to put it down to 500?
750, but you get half of it back. I mean, that's below the 500 if you're right.
Same rule.
Same
Yeah.
rule?
Okay.
Okay.
Yeah.
So does that take us on the appeal back up to the original new request?
Or is it still 1736?
Right.
Oh, right, the appeal of administrative determination.
If we're given half
That
back.
was your ceiling, and it was your time and material.
But did you want to keep it? So
At
it's
20.
17 now, and it's going up to 27.
Yeah, that's my question.
Oh,
Is you want to keep the 27 and then but we're giving half back if they win. Right?
Or do you want to keep it at the 17?
okay.
Still
All right,
get
all
one
right, all right.
back.
I'm with you now.
Okay.
We don't get many of these, do we?
No, not a lot. 3 or 4 a year.
Yeah, the one you decided today was the third one this year. Or third one from last
Well,
year.
for the sake of, I would just put it up to like 1950 or something. Just a little bit.
2000. Why would you go 1950? That is such.
1999.
Yeah, just
For
go
retail
to
pricing,
just go to 2000. Yes.
2,000.
We're not trying to
2,000.
2000.
Bill, 2,000?
Going twice?
Sold.
Bill 2000.
2000.
Thank you.
All right.
Yeah, if you have a coupon,
Okay.
And the half back if you win.
Thank you everybody for listening. Appreciate that.
That was for the
Reconsideration.
reconsideration.
All right.
But not the appeal.
So, no, the reconsideration 750, and then the appeal of administrative determination is 2,000. Both of those being able to get half back if they're successful.
Oh, well. See, I'm sorry. I was.
Where were you looking?
I mutually exclusivized those two. Then we should just keep the 2770 because if it's an appeal, I'm okay with the half back on that.
It's just coming up with the money in the first place. But, I don't know.
Well, I mean, generally these appeals are for significantly more expense. that they want to put into their property, right?
Well, it could be outside party though, so. Let's just do 2,000. We can absolutely review it again next year. We can review it mid-year. If we all of a sudden are inundated and it's getting out of hand, then we can review that.
Fair enough.
Okay. You have direction.
I do.
You do.
Thank you for your time.
You bet.
Thank you.
And 9:55, meeting adjourned. Thank you all.